We've got one final speaker on our agenda here. We've got Mr. Kent Chandler, who is a senior fellow at the R Street Institute and also a former public utility commissioner from Kentucky. Mr. Chandler, thank you so much for your patience with us, and you have the floor.
Yeah, thank you. I'll be honest, whatever else I could have been doing right now, I would much rather have a discussion about utility mergers and acquisitions. It's just kind of the nerd that I am. Thank you all very much for having me. Do you all mind to bring up, thank you very much. Next slide, please. So for those that may not know, I'm a non-resident senior fellow at the R Street Institute. I joined about 2 years ago, following a term as a commissioner at the Kentucky Public Service Commission, spending the last 3 years as chair. And before becoming commissioner, I was a staffer at the commission, wholesale market advisor and executive director at the PSC, and then spent almost 4 years as a consumer advocate. So I had about 8 years where I dealt with a handful of mergers, acquisitions, consolidation with utilities in Kentucky from varying perspectives. So the R Street Institute's a nonprofit, nonpartisan think tank that engages in policy research and outreach to promote free markets and limited effective government. Next slide. However complicated you think Virginia might be on the electric front, welcome to Kentucky. As a utility regulator, I regulated 23 distribution utilities, so either vertically integrated, it was 4 vertically integrated investor-owned utilities, 19 electric distribution cooperatives, and 2 generation and transmission cooperatives. The Kentucky regulates electric cooperatives the same as investor-owned utilities. There's no this sort of like light touch, I think, as some other states, maybe like Virginia does. Yeah, we regulate all the non-municipal electric utilities in the state of Kentucky. I did, with the exception of entities that get their power from the Tennessee Valley Authority. So if you want to talk about preemption, we can have a lot of fun at that conversation another time. Next slide. So I wanted, as part of this presentation, just to provide, I know I only have, probably about 10 minutes. I'm going to try to limit my presentation as much as I can to see if you all have questions, but I just wanted to provide my experiences and observations in Kentucky on this front. In my experience, utility consolidations are often driven by future earnings expectations. This can happen in a number of ways. I think most of what I'm going to say today is not really contrary to some of the other presentations, but I'm going to approach it from a different perspective. So the first one, sometimes this is called double leverage, but the acquiring holding company can seek to leverage lower cost debt and invest it in regulated assets as equity capital. It's not true arbitrage, but it's similar to it, but it increases total returns as the volume that it's applied to increases. So the more investment that you can make through this arbitrage, the more total money you can make. Buying more utilities, which utilities have a lot of investments needs, or having increased investment needs at the utility level for instance, to build or accommodate load growth, all else equal increases utility earnings. Consolidation can create O&M efficiencies. For instance, if you merge 2 utilities, you can find efficiencies with regulatory costs, compliance costs, legal expenses. You can create O&M efficiencies. I've seen it done before through internal operational changes. That lowers input costs that the utility includes in their cost of service. In a competitive market, I would say that those efficiencies provide an opportunity to lower prices, where competitive firms may be able to increase market share from lower prices and sell more commodity or service or whatever it might be, increasing their relative competitiveness. In the utility industry, I think it's more likely that O&M efficiencies create what the utility industry calls bill headroom. This is a term that I don't think is really defined in any textbook, but bill headroom is basically the amount, the level of your typical utility bill, residential utility bill, relative to the level of utility bill that I think utilities think customers would start to revolt or things would not work out well for them. So if you create O&M efficiencies, you lower the average bill or the typical bill, and it allows utilities to fill up that, quote, headroom with more investment, which they make money on, but don't make money on expenses. There is an opportunity to try to mitigate some of that, but it's not particularly easy. Some consolidation or M&A can result in access to more and cheaper capital. I think that that's possibly a case with the merger in front of the Virginia Commission. I can get into that more. But again, lowering that input cost allows the utility to make more investment for the same total cost of service. This is less of an opportunity for mature utilities. I've seen this actually be a big benefit for very small utilities that did struggle to have the same level of access as a Fortune 500 company might to capital. And then an opportunity to invest needed capital. If the acquired utility is having trouble accessing sufficient capital, or is otherwise just not good at making the investments that are needed, these needs are actually valuable for an acquiring utility. Next slide. So I've regulated utilities with operating companies within Kentucky and in other states. Some of those had joint assets. For instance, Louisville Gas and Electric and Kentucky Utilities owned portions of many power plants across the state. Regulated Kentucky Power, which I'll talk about more in a minute, which is a subsidiary of AEP and an affiliate of Appalachian Power. Some of you all, we dealt with a particular issue with Mitchell Power Plant, which was half owned by Kentucky Power and half owned by Wheeling Power in West Virginia. I know in Virginia, there was a similar saga with Amos and Mountaineer Power Plants, which are owned across jurisdictions. All of the utilities we regulated had joint costs across utilities or across affiliates. That included overhead costs, upstream business costs, particularly executive compensation. It's always hard to discern how much value executive compensation provides to consumers, and especially across different jurisdictions. Some of these entities access capital directly. For instance, Louisville Gas and Electric and Kentucky Utilities borrow money directly, while some others receive capital via affiliates. So for instance, NiSource borrows money on behalf of all their affiliates and then turns around and on a back-to-back basis loans that debt back to their affiliates at the same pricing that they get on a consolidated basis. Whether the extent to which and how you get capital actually matters for both risk and costs. For instance, for one example of that, NiSource has an electric affiliate in Indiana called NIPSCO. NIPSCO has created what is called a GenCo, a generation company, where when large data centers, for instance, come to NiSource's territory and seek to get power, a generation company is effectively created and contracts directly with this new customer and builds the generation necessary to do so. And it's not on the regulated utility balance sheet. So the idea is, well, because the cost and the risk isn't directly socialized with customers, customers are protected. That may not necessarily be the case. The capital for that GenCo is also going to come from the parent company when they go out and borrow money. And if the GenCo fails, that's going to raise the risk profile of the parent company and increase the cost of debt for all of the affiliates. Regulated a utility that covers many states. Atmos is a utility that is not a different operating company per each state. It actually is just the same utility that operates in many states. It can be hard to discern cost across states, although there are clearly some state-specific assets given their geographic location. And then I engaged with a few utility acquisitions. The one I won't forget is the acquisition or attempted acquisition of Kentucky Power. So for what it's worth, there's a lot of conversation about timing. In Kentucky, the M&A statute, the transfer of control statute, requires the PSC to rule on the request within 60 days. The request could be extended another 60 days, but if it's not ruled upon within the 120 days, it's deemed approved. So I'd love to have 6 months just for whatever it was worth. And the standard in Kentucky is that the commission shall approve any proposed transaction when it finds that the same is to be made in accordance with law for a proper purpose and is consistent with the public interest. So it's a little bit broader. It brings in the public interest, but it's not a particularly specific It doesn't define what the public interest is. The acquisition in Kentucky was a sale of the AEP affiliate Kentucky Power to Liberty Utilities for a little under $3 billion. It was Kentucky Power is about 165,000 customers, and yeah. So I guess I'll walk through real quick. The primary value, what I found in my experience is that the primary value of regulated utilities is their monopoly service territory, the obligation to serve customers that comes with that monopoly territory, then the need to make investments to meet that service obligation, and then finally the cost of service, rate recovery, and revenues that states provide utilities related to those investments. That's kind of the flow chart there. And I was the only, I call it my Judge Hudson moment, when I was the only regulator on the Kentucky Public Service Commission. I ruled on this Kentucky Power transaction, and the commission in that found, and I'll just, for the quote, for what it's worth, the value that Liberty is willing to pay extra for the acquisition premium above book value from AEP selling a public good, namely a state-granted franchise to be the exclusive electric service provider, which includes the opportunity for significant investment in infrastructure and a regulatory scheme that provides the utility mechanisms to seek recovery of and on its investment. That was where the commission found the reason was, that was the reason we found that it was obvious Liberty was willing to pay in excess of book value, because it was a place to put their money and earn a higher return. There was a massive value to Liberty because AEP had underinvested in the Kentucky Power system. And for years, AEP chose to allocate capital to other Kentucky affiliates for transmission distribution investments, likely due to better regulatory outcomes and higher risk-adjusted returns. The Kentucky PSC actually approved the acquisition with conditions. We found there was substantial evidence that AEP had underinvested in Kentucky and that it would be a benefit to consumers for the sale to go through. However, the Kentucky PSC objected to the sale or the transfer of control at FERC. We hired an attorney and intervened directly at the Federal Energy Regulatory Commission and objected to the proceeding because we believed that the applicants had failed to abide by FERC's merger policy statement, which required applicants for a transfer of control to identify the possible impacts or harms to rates and mitigate those harms. FERC agreed. FERC ultimately rejected without prejudice the application, agreeing with us that they had failed to meet their burden of proof. The utilities then refiled the proceeding. I actually forget whether we actually objected or indicated it was our intent to object again on the same basis. And ultimately the sale fell apart, I think, because the writing was on the wall that it was not going to meet. They were unwilling to do what they needed to do to meet the FERC policy statement. All right, next slide. I'll just do this part very quickly. You can mitigate a lot of the, I'll call them harms or possible harms of a merger through subsequent utility regulation. But I agree with Josh Macy. Your prime opportunity to mitigate those is during the transaction. Things just become harder after the fact, even if you have state laws intended to mitigate those harms. In practice, because of information asymmetry or preemption issues, it's just easier to address them at the time. One thing I'll highlight is a capital allocation issue post transactions. I frankly found the most frustrating thing as a utility commissioner, sort of this race to the bottom for attracting capital, that multi-state utilities go to each one of their commissions and basically tell them, we will not invest here or not invest to a particular level here in the state unless you give us A, an appropriate return, and B, give us that return in our capital back quickly. So, an increased risk-adjusted return. And that's frankly an incredibly frustrating thing for a commissioner, because they're hoping every state joins the race, and all that does is raise rates faster and joins the other states in that. Cost allocation is not easy. I wish it was. The job would be a lot easier. But yeah, happy to talk more about that if there are questions. And I guess a personal view is I've seen this happen in other states, especially when like private equity has attempted to purchase utilities in some of these states, that there's an outcry from the public that rates are going to go up or things are going to get worse or services are going to go down. If the source of the change is exclusively access to different capital, a risk that things are going to get worse post-transaction are actually a reflection of poor regulation or concern around poor regulation. Just changing where the money comes from shouldn't change the ability of a regulator to say no or statutory scheme to protect consumers. And so, oftentimes there are opportunities to change the regulatory scheme or just how the regulations are implemented to mitigate concerns around, new sources of capital.
Thank you so much, Mr. Chandler. We really appreciate you sharing your time and your expertise and direct experience as a commissioner with us today. I don't see any commissioners in the queue there. Okay, I've got Delegate Weber in the queue. Yeah. Delegate Weber, please go ahead.
Thank you, Madam Chair. So I guess a couple of questions, if I can be granted a little bit of leeway. So you said that there were three things that would drive a purchase of this. Basically, the monopoly that one of the entities has, the capital needed for that entity, and in this case, I believe that we are facing not only increased base load, just the needed generation from data centers and residential growth, but also the fact that our regulatory process, we need a certain amount of clean generation as well that has yet to be built. And then also there is a rate of return. So our SEC determines that rate of return. Would it be correct in saying that that a conglomerate of all three of those things created the atmosphere for the current reason we are here?
I guess I don't know that. I guess are you asking? Is this sort of have you all created a perfect storm for this acquisition? Is that basically?
Yes, sir.
Question? Yeah, I don't know. I think there's a lot of things that drive it. I'm pontificating just a little bit, but I think that had federal policy not changed earlier this year to reduce the outsized amount of subsidies provided by, I guess it was last year maybe, but renewable energy, for instance, that NextEra intended to put their money in, where they have the money available. I think it's probably a lot of factors that have led to this. I don't know that you can narrow it down to those three, but I think it's fair to say that all of those things contribute to the proposed transaction.
One last question, Madam Chair.
Delegate Weber, go ahead.
Thank you, Madam Chair. Okay, so kind of piggybacking off of what RIP Delegate Sullivan had done earlier. So we have the governor intervening in this and going before the SEC. We have our Attorney General and his office that intervenes on this on the consumer behalf. If a legislator who represents Virginia, as all of us do, were to intervene or basically ask the SEC questions in regards to what we would like to see, what would you say?
How would I prosecute your case as an intervener?
Yes, sir.
Yeah. I think that's a fair question. I think having a real appreciation for what the post-merger transactions and intra-company sort of engagements would be, I think, is the primary. I think one of the primary places that I would look. I find that, and I haven't dug into the record in this case, but one of the things in my experience is that in utility mergers, acquisitions, consolidation, that there's a lot of it's very easy for utilities to say, well, we haven't actually figured that out. Let us get back to you, but that's something we plan on figuring out post-merger. And I think that that allowing that to happen in any transaction effectively limits the opportunity for the regulator to step in and mitigate harms before they occur in a way that probably makes it pretty hard to mitigate it after the transaction. And so I think the one of the most important places that regulators can ask questions about and push on is to provide post-transaction clarity on what the intentions of the affiliates are after the transaction closes, so that they have an ability to identify how they intend to conduct their business, probe on whether they believe there are harms that may result on how they conduct that business, and then put in conditions that limit possible harms to consumers. I think that was one of my biggest frustrations, is that utilities often would just say, well, we haven't figured that out yet, and we'll let you know a couple of years from now when we intend to do it. And all that does is obfuscate an opportunity to protect captive consumers.
Thank
Thank you so much. I'm going to move on to Commissioner Navarro.
Thank you, Madam Chair. Madam Chair, Mr. Chandler, did you happen to read the Virginia Affiliates Act?
Yeah, only after you asked the question about it.
Okay, great. I'm glad I prompted you in advance. Madam Chair, one more, yeah.
Sure, Commissioner Navarro.
Okay, great. After reading it, do you think that the Affiliates Act provides a structure to mitigate some of the challenges we heard from prior presenters around affiliates concerns, or do you have other suggestions or recommendations relative to that legislation, that piece of statute?
Yeah, I think it's a so I commend Virginia in having affiliate transaction laws written in statute. I think that makes them stronger. In my experience, in many states, some states, the written regulations or commission precedent in a way that probably doesn't give them as much teeth. I think it's helpful, but probably insufficient, because affiliate transaction laws, I'll say it this way, affiliate transaction laws like certificate of public convenience and necessity, or the laws that require utility commission approval prior to entering into evidence of indebtedness and other securities and things like that, all are effectively just a veto against terrible proposals. They don't necessarily ensure positive outcomes. So for instance, if a utility shows up and says, I want to buy this power plant from an affiliate, arguably the commission has the ability, if it's a bad proposal, the commission arguably has the ability to deny that proposal. It, however, does not give the positive authority to the commission to direct the utility to actually make a good transaction, buy the appropriate or the lowest cost power plant, or contract with the best counterparty. It's only a veto against things that are bad. And then second, I think implementation of statutes like that I find are really difficult, because there is such an information asymmetry, and you're effectively trying to do what is like a real-time prudence review, and there's always not a lot of it's always not obvious what the alternatives are. You're limited to the alternatives as presented by the applicant. And then finally, I think there are concerns that I would have, again, just having scanned this in 2 minutes after you asked the question about 20 minutes ago. I do have concerns about sort of preemption issues. I have a personal experience in Kentucky where a utility was denied an ability to enter into an affiliate transaction, and then so the utility just went to FERC and entered the exact same transaction, but under FERC jurisdiction, in a way that the commission had its hands tied from actually doing or saying anything about it, and that the two transactions were effectively identical, but the commission for decades after that was preempted from mitigating any of those harms because it was a FERC-approved transaction and it was a FERC-approved rate.
Thank you so much, Mr. Chandler. I've got one last commissioner in the queue, Delegate Sullivan.
Thank you, Madam Chair. Mr. Chandler, I want to ask you about the very last bullet on your last slide. I think you skipped it.
One thing yeah.
Yeah, market power is an important but often overlooked issue. I wasn't sure whether you meant market power can be a good thing and is often overlooked, or market power can be a bad thing and is often overlooked.
Market power is always, well, I'll say, is market power always a bad thing? Yeah, at least in the short term, market power is always a bad thing. Yeah, market power is an issue, I guess, is what I would say. But it's often an overlooked issue, particularly at the retail level. So if, for instance, let's just say hypothetically, if a retail regulator requires a utility to go to market for a significant portion of its generation, but that utility also owns or has owns so much power in the wholesale market that it has market power in the wholesale market, it actually could have the ability to contract at wholesale for higher costs than it would be able to build it, for instance, at the retail level. So that's like a theoretical harm, but it's one that could actually impact retail rates. Wholesale market power is depending on where the intervention is the states would be preempted from taking certain action. But there is an ability, I would say, like in a retail merger transaction, to actually look at that as a possible resulting harm that impacts retail rates. That could, I think, serve as the basis for a retail regulator's decision, even though the regulator doesn't have jurisdiction over wholesale market power, for instance, if that makes sense.
I think it does. I think it does. Thank you, Matt.
Thank you. We actually have a couple of additional commissioners who have popped up. I'm going to first go to Commissioner Browder, and then Senator Serval, I see your hand as well. Start with Commissioner Browder.
Mr. Chandler, first of all, nice to see you again. Thank you for being here. Really appreciate your clear and concise comments based on your experience from being in the trenches and these things. You touched on this issue of allocation of resources in a kind of multi-state holding company situation, and you referenced the kind of race to the bottom idea. And as you know, you touched on Appalachian Power Company. That's part of a multi-state holding company now that's operating in Virginia. But let me just throw out a hypothetical. Let's say if the merger goes through, and let's say we have Florida Power and Light in Florida operating under let's say a 10.95 approved ROE by the Florida Public Service Commission. And the Virginia Commission, let's say they would approve in Dominion's next rate case, say a 9.5 ROE. I'm just kind of making up numbers here, but what is that what would create the issue you raised about allocation of resources and the utility saying, oh, you can't give us less than what the Florida Commission gave our affiliate company because they'll send all the capital down there. What tools or what power do you believe the Virginia Commission would have to ensure that that does not happen and that needed capital is devoted to the Virginia utility in a situation such as that?
Yeah. So, good to see you again. This is actually something that I spent a lot of my sort of time thinking about since leaving the commission, because it was one of the things that troubled me the most as a commissioner in Kentucky. And I will admit to you that I don't have a complete answer, because when I do, it'll finally show up in a paper I've written on answering this. That is okay. So taking a step back. Your hypothetical is a portion of sort of what I was hoping or attempting to convey there. I think approved return on equity is part of it. So I think approved return on equity, the level of equity, or the return on equity is a part of it. The approved return on equity is a part of it. The second part is the level of equity in a capital structure. So if one utility is approved at a 10.5 ROE, but it only has 30% of its capital in equity, and the other 70 is debt, while the other utility is a 9.5 ROE, but it's a 60% equity, that automatically changes the sort of the tune for relative levels of investment. I think earned ROE plays a huge part in this. So I think I'm using utility terms here, but the timely recovery of their investment is a huge part of this, because that's a risk-adjusted implication. So are they approved at a 10.5? But what are they actually earning, and when are they actually able to make the money back, right? Is it a situation where they're approved at a 10.5 and for the first year they don't get recovery, but when they show up for a case, it's sort of like all rushes in at once, and then in the second year they earn above a 10.5. Like, I think there are a lot of considerations. When I heard it, it was approved ROE. It was earned ROE more than it was approved ROE. That was the first one. And the second one was the timely recovery of investments and costs, and the use of the term regulatory lag was usually pretty heavy. And it was about when they could get their money at an approved or higher ROE. I think all those things were things that were sort of implicated or brought up in this request for Kentucky to join the race to the bottom. And then the final one, it was always framed in this idea that utilities had extra money lying around at the holding company level, and an argument always that, don't worry, the holding company will always give us enough capital to make our needed investment. But boy, wouldn't you like to attract economic development, or wouldn't you like to fix the leaky pipes, or wouldn't you like to do these other things that are over and above the needed level of investment? Kentucky is not going to be considered for the allocation of that discretionary capital until or unless it raises ROEs, makes it easier for utilities to earn them, provides them trackers or other mechanisms to recover that cost earlier. It was always that sort of, there's some pile of money sitting there, but that Kentucky's not on the list for it because, inner reason here. I don't know that commissions are well set up or have all the tools in the toolbox to address this issue. This is what I really do think about a lot. And one of the things that most commissions don't have, and I think about it in the context of what can legislatures do to give, this is what I'm about to say is like, I've not fully fleshed it out. But one thing that legislatures I think can say is like, you can either use a carrot or a stick. And I think carrots run the risk of incentivizing bad behavior or rewarding folks for effectively making threats against the state. And I use the word threat because I can't come up with a better word. I do think that the state really doesn't have very many sticks. And I go back to what I believe the value of monopoly utilities are, which is that defined service territory. And I think that unless there's a risk that a utility can lose their service territory or have their monopoly from competition or their protection from competition removed, that it runs the risk that they're going to continue to engage in bad behavior, because there really aren't a lot of tools available to regulators to hold them accountable otherwise. For commissions to come down and like penalize utilities, like they have to really have done something bad, and the record has to be pretty deep for that to happen. And just sort of, the argument that the holding company is sending more money to another state is probably not a basis in most any states to find a utility operating company. So I know it's probably not as direct as you were hoping for, but that's sort of the thing that keeps me up at night.
Thank you.
Thank you so much. Senator Serval, do we still have you?
Yeah, we do. Thank you, Madam Chair. Mr. Chandler, I heard your comments earlier about how the Kentucky legislature hamstrung y'all with a 60-day review period, and I know in Virginia was 6 months. We've had some talk about looking at extending that. I know Kentucky's about half the size of Virginia in terms of its size. It sounds like you got maybe twice as many utilities as us, even though you're half as big. I suspect the mergers you're looking at probably were not $69 billion. I mean, do you have a sense as to whether, you as a commissioner could have adequately scrutinized a $69 billion transaction with a 6-month period?
Yeah. Out of deference to my friends that serve as judges on the Virginia Corporation Commission, I won't answer that directly. I'll speak from my perspective. I find that regulators in any industry, and maybe this is actually just government folks in general, although I'm finding it out of government too, we all tend to be gases. We tend to fill the volume of the shape of the container that we're in. If you give me 6 months to do something, it'll probably take me 6 months to do it. If you gave me 8 months, that'll be fine too. But I probably won't get it done in 6 months. I think that the sheer size is one thing, but I don't think that the size is necessarily always a reflective of the complexity. I think that you can have a big transaction and not be particularly complex, and I think the vice versa can be true as well. I would say that a big portion of it is how well resourced a utility regulator actually is. When we did the transaction in 2021 and 2022, or I guess 2022, the Kentucky Power, we probably had low 70s in terms of staff at the Kentucky Public Service Commission. That's up from 60s in the 2019, 2020 level, but down from about 115 from a couple of decades before. And then, your level of experience, people you have, the technical capabilities you have, the ability of regulators to get like outside assistance or modeling. I mean, I think there's a lot that goes into it. I don't think that it's never made sense to me that people need a year to do like complex rate cases or transactions or things like that. I think there's probably a sweet spot, and it's probably somewhere between the 120 days that we had in Kentucky and 12 months. And I think the variables that contribute to that, are the complexity of the transaction, the resources that the regulator has, frankly, the statute that it's operating under, and then how it processes cases, how many interveners it has, the ability to sort of have an orderly hearing, for instance, with how many conveners you have. I think there's a lot that goes into it, but I think something between 4 months and 12 months just seems right based on my experience.
Thank you so much. I think, Senator Serval, unless your hand is going to stay up because you have another question, I'm going to say thank you to Mr. Chandler for your time again this afternoon.